in Mr. Datar's submission, my lord, all four are together, so that may be relevant. That is, my lord, page 32 of volume 1 of the compilation. That has all the written submissions.
Fortunately, is not that bulky as the earlier CD.
The written submissions are, we've kept them short, my lord, all our written submissions.
Yes.
Page 32, your lordship will find, my lord, where Mr. Datar's submissions start. In para 1.1 are the first two questions: whether a judicial officer who has already completed 7 years in bar being recruited for subordinate judicial services would be entitled for appointment as additional district judge against the bar vacancy. So this is somebody, my lord, who already had 7 years before becoming a civil judge. All my clients would not fall under this. They all, my lord, became civil judges before they completed 7 years at the bar. Then 2, whether the eligibility for appointment as a district judge is to be seen only at the time of appointment or at the time of application or both. Then 3, whether there is any eligibility prescribed for a person already in the judicial service of the union or state under Article 233(2) of the Constitution of India for being appointed as district judge. And 4, whether a person who has been civil judge for a period of 7 years or has been an advocate and civil judge for a combined period of 7 years or more than 7 years would be eligible for appointment as district judge under Article 233 of the Constitution of India. All my clients would fall under this category. The fourth category.
7 years of combined experience.
Yes, they all have 7 years of combined experience, including whatever they did as a lawyer before becoming civil judge or as civil judge or including both. Now, my lord, just have a look at the article.
You are concerned with which are these features?
I'm sorry.
All the four.
Yes.
According to him,
So,
if,
Lord-
if clause 4 is answered in affirmative, then his client would be
Yes.
covered
Yes.
by that.
Yes. Yes.
We are in two categories. One is covered by question 4, the other is by
That's
question.
it.
My clients are also in question 1. We have 7 years before being appointed as civil judges, and we say we don't want any benefit of our service as civil judge. If we are appointed, we will quit and then we will join. So can we be disqualified?
One minute.
Question 4 is.
Question 3 is important.
It says that you concentrate more on question number 4. Because in the event question number 4 is answered in the
All
affirmative,
the others get through.
everybody will get it.
Right. Right.
And first 3, question 3.
It's okay. Lord, your lordship will have a look at Article 233. It comes under, my lord, Chapter 4 of Part 4. Sorry, Chapter 6 of Part 6, which is the subordinate courts. Part 6 deals with the judiciary. This is subordinate courts. Appointment of district judges. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of that state in consultation with the High Court exercising jurisdiction in relation to such state. 2, and we are concerned more with 2. A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. Now, my lord, 2 constructions have been made for this sub-article. Dheeraj Moore, etc., has said that when it says a person not already in the service of the union or the state, it means that he should not be in the service of the state, which according to us, my lord, is completely wrong. The way I read it,
According to you,
yes,
the requirement of 7 years
yes,
would be applicable only to an advocate who is not in service.
correct. Absolutely right. And therefore, my lord, this qualifies or, my lord, makes 2 categories of people eligible. One is those already in the,
Advocates and one who are already in the service of the
correct,
union and the
correct.
state.
So those, otherwise, my lord, our submission is that these words, not already in the service of the union or of the state, will become redundant. Your lordship may just look at my written submissions, my lord.
So according to you, then the provision in the constitution
Yes,
would have been that to be eligible to be appointed as a district judge, he has to be an advocate for 7 years.
correct.
That would have been simply
Right.
the provision in the
If your lordship has, my lord, my written submission, which is page 1 of volume 1, and come to page 5. Page 5, my lord, about 6th line, I have quoted that part, Article 233(2) minus those words which my submission is would become superfluous or redundant if their construction were to be accepted. Now just read it, my lord, as I've taken off those words. A person shall only be eligible to be appointed a district judge if he has been for not less than 7 years and as advocate or pleader and is recommended by the High Court for appointment. This is what would have been sufficient if what they are saying is correct, namely that you have to be an advocate or a pleader. If you are a district judge today, then you cannot, or if you are a civil judge today, then you cannot be eligible. Then, my lord, those words have become completely redundant. So therefore, and it's a well accepted principle of law, that any construction of a statute, or in this case, the constitution,
which
which-
makes the provision redundant.
which makes any words redundant,
Or rather than each and every word
has to have some
given
meaning.
its meaning.
Correct, correct. Now, I have, my lord, I'm relying on 3 judgments for this proposition.
Explain this.
First, my lord, this is in
Person in service is a judicial service.
Yes, that has been clarified by Chandra Mohan, because, my lord, the constitution didn't say it, but Chandra Mohan later qualified by saying, yes, service means
It's
judicial
a judicial
service.
service, yes.
Yes, yes, correct.
Why does it say union? Judicial service, why does it say about it? This is comes
Because
to the state.
there is a historical concept, my lord. As I go along, I'll show your lordship how the history of this, my lord, appointment of district judges happened. That's why it says you.
Revenue officers were also eligible at that time
Correct.
for being elevated.
Correct, my lord. Till Chandra Mohan, all officers, in fact, I'll show your lordship, my lord, the act and the rules earlier, pre-constitution, who was eligible.
That's what it is, price. Chandramohan says even if it's located in a later article, we use the same definition. What flow?
Yes, give me the relevant paragraphs of answer. Paragraphs.
Page 588.
Para?
281. Internal page 281. Two more.
Lord, if your lordship turns to volume 5, sub-volume 2. This is that volume 5 is the case law volume, my lord.
The new one.
it's there, my lord, in the compilation which has been uploaded. Volume 5, sub-volume 2. And this judgment starts at,
Which, Rameshwar?
no, my lord. I'll first only on the point that no words of a provision can be made redundant.
Settle law, but they just.
That's correct, my lord. So just one very quickly, one paragraph from that judgment. This judgment starts at page 580,
518.
580, my lord, and the relevant part is at 588. I'll just give your lordship the citation of the other two judgments which I am relying on for this proposition. I don't need to show it. As your lordship said, this is a well accepted principle. At page 588, my lord, between placetum D and E, in Quebec Railway,
1 minute. Holy Devi.
yes, Hansoli Devi. And I'm reading, my lord,
1 minute.
page 588, which is 281 of the
It
report.
begins at page
It begins, my lord, at page 580.
5.
80. And I'm reading, my lord, page 588. Just one very short 4 lines.
Yes.
Between placetum D and E, in Quebec Railway. Your lordship has that? In Quebec Railway, Light Heat and Power Company Limited versus Vandry, it had been observed that the legislature is deemed not to waste its words or to say anything in vain, and a construction which attributes redundancy to the legislature will not be accepted except for compelling reasons. Two other judgments, my lord, which are Rao Shiv Bahadur Singh, 1953, 2 SCC, page 111.
Rao Shivbahadur Singh.
1953, 2 SCC, page 111.
1 minute, 1 minute.
Yes, I'm sorry.
Rao Shivbahadur Singh versus.
Let's take out the thing. State of UP.
Are they mentioned in your?
Yes, they are there in the compilation, my lord. Your lordship can take it that they are in volume 51. 51. First and second serial numbers.
Give us the page number
Yes, my lord. The first one is page 2
of the compilation.
of volume 51 of the compilation.
Yes.
And the second one is page 72. The first one, my lord, which is Ashwini Kumar Ghosh, the relevant paragraph is para
The
26.
first one is Rao Shivbahadur Singh or?
First one, my lord, in the compilation is Ashwini Kumar. Paragraph of that is 26. And Rao Shiv Bahadur Singh, which is at page 72 of the compilation, paragraph of that is 10.
Paragraph?
10.
Then, and here para 26. In Ashwini Kumar, para
26, para 26. So therefore, my lord, any.
You will get n number of judgments on this.
Yeah, correct. Your lordship is right. So,
No word of a statute.
right. You can't attribute redundancy to the legislature. Why would they have added those words there? In fact, my lord, the history would make it clear as to.
Does it become redundant according to you?
Lord, I had given your lordship, my lord, the same 233(2).
That only the advocate having a 7 years practice to accept it. Then the first part, there are a person who is not already in service of state and union. That will be rendered OTO.
It's more of a clarification according to them. Not OCS, that's what we get. According to them, probably it is only more of a clarificatory. They want one way of exclusive.
If they are saying that it is only advocates who are eligible, then what is the use of saying government servants are not eligible? All sorts of people are not eligible. Why would you specifically lay down government servants are not eligible? Supposing the words that not be already being in the service of the union or the state were not there. And the only words were that a person has to be an advocate for 7 years. That in any case excludes those people not being in the service of the union or the state.
This way, you have to see whether it is clarificatory or not. Certain statute and even the constitution also which says it can combine both exclusion and inclusion. We have tried to tell you, in the first part it excludes, and other part it includes.
Lord,
That one way, but therefore it will not become redundant that way. How
clarificatory.
to interpret the provision is one thing.
Yes,
To
yes.
say because of that it will become redundant may not be correct.
Lord, clarificatory would only be in a situation where there is any confusion. Now, Lord, in my written submission, I had,
You can very well say.
yes,
Is 233 232 wants to make it doubly clear that the law advocate should have 7 years while they differentiating between the others. Therefore, this 7 years qualification is not foreseen for them. Therefore, you can apply it that way.
my Lord, construction.
This qualification of 7 years meant for only lawyers.
Yes.
And then it may not meant for the others. That may be the one way of argument. Or there are, on the contrary, their argument is going to be, yes, it is only meant for 7 years. In that process, they want to exclude this.
But they would be excluded anyway.
Yes, sir.
Supposing, my Lord, just
Only a language, we want to see the ultimate meaning what is conveyed. There is no exclusion per se that way. It's only the understanding of the provision.
First, try to
Yes,
let them at least begin.
Now, my Lord, next I want to take your Lordship to a little bit of, Lord,
Yes.
history. Lord, under the Indian Civil Services Act, where is that page? Fancy volume, huh? If your Lordship has volume 4 of the compilation, this is, my Lord, at page 12 of volume 4 is the Indian Civil Services Act. I'm sorry for the poor print. We couldn't get a better print anywhere. You have that copies of that other thing? If your Lordship has, my Lord, page 12 of that compilation, volume 4, Indian Civil Services Act 1861. Actually, we had a better print, but it didn't have the heading, the Indian Civil Services Act, so it was a little confusing.
Yes.
If your Lordship has, my Lord, on the same page, section 2.
All vacancies happening in any.
Yes, all vacancies happening in any of the offices, places, or employment specified in the schedule annexed to this act, and all such, what is this? Offices which may be created hereafter shall
We filled up.
be filled up and supplied except as hereunder provided from amongst the, what is it? Covenanted civil servants
Among
of the
the
Crown in India.
wanted staff, civil services.
From
the
amongst
Crown
the
in-
covenanted civil servants of the Crown in India. So, and if your Lordship has the next page, the schedule under judicial, the posts are civil and sessions judge, which is today the district judge and sessions judge, or chief judicial officers of districts in the provinces now known as regulation provinces, additional and assistant judges in the said provinces. So, my Lord, for these posts, only persons from the civil services could be appointed. That was the position in 1861. So there was no question of any, my Lord, lawyers, etc. It was only from civil services that district judges could be appointed at that stage. Then your Lordship may have, my Lord, the Government of India Act 1915, which is at page 47 of this compilation. It starts a little earlier, but I'm reading, my Lord, section 98 and 99, which is at page 47 of the compilation. Your Lordship has that, my Lord? Section 98 at page 47. Subject to the provisions of this Act. Section 98 I'm reading.
Yes.
Subject to the provisions of this Act, all vacancies happening in any of the offices specified or referred to in the third schedule, and I'll just show the third schedule that includes this district judge, etc. And all such offices which may be created hereafter shall be filled from amongst the members of the Indian Civil Service. Then there is a kind of a proviso, that next section, section 99. The authorities in India by whom appointments are made to offices in the Indian Civil Service may appoint to any such office any person of proved merit and ability, domiciled in British India and born in British India, of parents habitually resident in India and not established there for temporary purposes only, although the person so appointed has not been admitted to that service in accordance with the foregoing provisions of this Act. So there is a power to appoint people who are not in the Indian Civil Service, and that is to be done by rules, which is 99(2). Every such appointment shall be made subject to such rules as may be prescribed by the Governor General in Council and sanctioned by the Secretary of State in Council with the concurrence of a majority of votes at a meeting of the Council of India. And the third schedule, your Lordship will find at page 61. That is that these offices normally from the civil services, but the authorities can appoint from others also as per rules. And these offices include, my Lord, at page 61, part 2 of that bottom. Offices in the provinces which were known in the year 1861 as regulation provinces. 7. District and sessions judges. 8. Additional district or sessions judge and assistant sessions judge. Now the rules are very important, and that is, my Lord, at page 100 of this compilation. This is the notification dated 30th March 1922 as amended by notification dated 17th May. Lord, that handwritten correction is on the website of the government itself. This is how it is there. Now, Rule 1 says, with the previous sanction of the Governor General in Council and of the Secretary of State in Council and local government may, by notification in the official gazette, declare the number of superior executive and judicial officers being offices ordinarily filled from amongst the members of the Indian Civil Service, to which, subject to the provisions of subsection 1 of section 99 of the Government of India Act, persons not being members of the Indian Civil Service may be appointed. 2. Within the limit of the number declared under Rule 1, the local government may appoint, and your Lordship will straight away have Roman 2 because Roman 1 refers to executive office. 2. To a superior judicial office, a member of the provincial civil service, subordinate to the local government, or a person who at the time of the appointment is a barrister of England or Ireland, or a member of the faculty of advocates in Scotland, or B, a vakil, pleader, advocate or attorney of a high court in India, or C, a pleader or advocate of a chief court or of a judicial commissioner's court, or D, a pleader of a district court, etc., etc. So therefore, Lord, two streams are very clear. One, that he is a person, a member of the provincial civil service, subordinate to the local government, or a person who is a barrister, vakil, pleader, etc. So this is the history of how Lord 233 has come. Those two streams, namely a person who is a member of the provincial civil service.
But whether the superior judicial service is defined?
That your Lordship saw, my Lord, in the third schedule to the Act, the Government of India Act 1915. That was, my Lord, at page.
It says offices in the provinces which were known in the year 1816 as Regulation prohibits.
So these are the regulations made under, these are the rules, my lord, made under section 99(2). If your lordship comes back to the
Yes.
Government of India Act 1915,
1992, so which permits even those persons who are not in Indian civil services and who
yes,
are,
yes, correct.
who are
correct. So
domiciled in
therefore,
to be appointed.
so even at this stage in 1915, 1922, 23, those who were in the civil service could be appointed district
Yes.
judges. But apart from that, those who were in the provincial service or those who were advocates, barristers, vakils, pleaders, etc. That came by way of, my lord, the rules made under this 1915 Act. So that, my lord, the notification of 1923, namely either member of a provincial civil service subordinate to the local government or a person who was a barrister, vakil, pleader, etc., came by this. And that is how, my lord, when the the Government of India Act 1935 came, Article 254, which is the precursor to 233 in our constitution, my lord, came, which is more or less the same. Your lordship will have a look at it at page 136 of this compilation. (254) of the Government of India Act 1935. District judges, etc. Appointments of persons to be and the posting and promotion of district judges in any province shall be made by the governor of the province exercising his individual judgment, and the High Court shall be consulted before a recommendation as to the making of any such appointment is submitted to the governor. To a person not already in the service of His Majesty shall only be eligible to be appointed a district judge if he has been for not less than 5 years a barrister, member of the Faculty of Advocates in Scotland, or a pleader, and is recommended by the High Court for appointment. So more or less identical, except that 7 years is 5 years. So this is, my lord, how 233 came pursuant to. So the history of it shows that initially,
According to you, sub-article 1 and 2
yes,
are drawn from 254, 1 and 2.
yes. And 254 of the Government of India Act, my lord, was from the earlier thing, namely where people from the civil service were, my lord, eligible to be appointed. Provincial civil, initially only ICS.
According to even after 1935,
Yes,
the practice of people being appointed from the ICS,
yes,
also from the bar,
yes.
that continued.
That continued, not just the ICS, also from the provincial civil services, from the civil services. So a person not already in the service of His Majesty shall only be eligible. So therefore, my lord, this has been coming from that period, and this is the background in which your lordship has to interpret 233. Why it said a person not already in the service. Namely, a person who is already in the service is eligible anyway. A person not already in the service is eligible if he has been an advocate for 7 years. And that ties in, my lord, with my submission that otherwise it would make those words redundant. Then, my lord, before I take your lordship to Rameshwar Dayal and Chandra Mohan, which are the two most important judgments,
260 of the Constitution debate. Page 260, Constitution debate.
Before I take your lordship to those two very important constitutional bench judgments, I want to show my lord what happened in the Constituent Assembly debates.
Yes, that,
Although
Maybe-
not very much happened, but there is something relevant. So if your lordship has, my lord, page 259 of this volume 1, that volume 5, volume 4, the same volume that your lordship was reading just now. Page 259. Towards the bottom of the page, the last 7 or 8 lines, Article 209A. Does your lordship have that, my lord? 209A was the draft article which became 233.
one and 9A.
Yes. Does your lordship have that page, my lord? 259?
Yes,
Yeah, I'm sorry. The Honorable Dr. B.R. Ambedkar. Sir, I move that after Article 209 between chapters 7 and 9 of Part 6, the following be inserted. And then 209A is quoted, which is identical to 233. And then, my lord, on the next page, 260, if your lordship has just below the middle of the page, paragraph beginning, sir, the objects. After, my lord, the entire thing is quoted up to 209F, which takes us to, my lord, 237. Just below 209, at page, my lord, 260, the last paragraph, sir, the object. I'm reading that part. Sir, the object of these provisions is twofold. First of all,
where is it?
my lord, the last paragraph on page 260.
Sorry.
Sir, the object of these provisions is twofold. First of all, to make provision for the appointment of district judges and subordinate judges and their qualifications. So therefore, my lord, this article provides for qualifications of district judges. Whether now appointment of district judges would include whether it is by way of direct recruitment or promotion. Appointment is to a post there are two ways of getting appointed to that post, either direct recruitment or promotion. So if you are laying down qualifications to be appointed district judge, and that qualification, as my learned friends on the other side would say, is only 7 years an advocate and not being in the service, then, my lord, how can civil judges even be promoted to district judges if the qualification is only, according to them, 7 years an advocate? Because, as your lordship sees, my lord, from these debates, this article is laying down the qualifications as well. And if you limit the qualification, if you take away those in the service, those in the judicial service, which is what we are reading, then, my lord, it leaves only 7 years an advocate. So how can a civil judge even be promoted to district judge? Because then he's not qualified.
You respect, they are not saying so.
I'm sorry, my lord.
Nobody's saying.
Saying so.
Nobody's saying.
They are not saying, they're saying that they are only saying how to reckon the 7 years. That's the only thing.
Nobody's saying.
You cannot, that triggers, 7 years means only as a lawyer you should be there. That's
So
all.
they are saying that
Promotion, they are not
233.2.
saying.
Lord, let's see what they are saying. Just come back to 233.2.
It has to be very clear, they are not making that statement. What they are saying is that.
No, they may not be saying it.
That's not problem.
But because
But-
they are saying,
This only with five,
they are saying, my lord, that civil judges are are eligible for promotion. But what I am submitting before your lordship is this: if, as Dr. Ambedkar says, this this entire lot of articles from 209A to 209F, which is 233 to 237, lays down the qualification of district judges, a qualification of persons to be appointed district judges. That qualification is only in 233(2). Nowhere else. None of the other articles says that. Now, how do we read 233(2)? They say that 233(2) is excluding civil judges, and the only qualification that is prescribed is 7 years an advocate. If that is the case, my lord, I ask myself the question, then how do civil judges get promoted? Because that's also an appointment. They cannot get promoted. The object of 233(2) is to lay down the qualifications. No,
Well, let us put their case. Their case is simple. 233 alone you command that. 233(2) is meant for them. It's as simple as that. For that purpose, it makes clear, it excludes the somebody who's in employment of state and civil union. That's the thing.
I'll meet that also. I'll meet that also.
Argument would only be, it is not their argument, therefore we do not blabber much on that.
That would not be the argument.
What they are saying is, for the direct recruitment, the 7 years is only for the lawyers alone. That 7 years qualification, they have been excluded from 233(2), not 233(1).
Therefore, my lord.
233(1) speaks about promotion.
Correct.
It can be done.
So therefore, my lord, according to them, where does the eligibility of civil judges come from under these articles? Because obviously they have to be eligible for being promoted. They have to be eligible for being promoted. Where is that eligibility coming from? According to me, that eligibility is, even if they were to be promoted, for a moment, let us argue against me, my lord, that their only avenue is promotion. Where is that eligibility laid down in Article 233, 234, 235, 236, 237? According to me, there is no other place except 233(2).
No, 233 deals only with the district judges.
Correct.
Then 234 deals with the recruitment of persons other than the judges.
Yes,
It provides for making of the rule.
right. Therefore, are they saying that the eligibility of civil judges to become district judges is coming only by way of the rules? In my humble submission, that's why I referred to, my lord, the Constituent Assembly debates, namely that these articles are providing for the qualifications for being appointed as district judge. And that, in my humble submission, would include the qualifications for being promoted as district judge also, because promotion is also appointment. Appointment is.
The word also use promotion. Words used in sub-article 1
Yes.
also use the appointment, posting and promotion.
Yes, yes. So therefore, my lord, your lordship is right. But generally, the appointment includes, in fact, my lord, under the UP Judicial Service rules, your lordship may straight away have that, my lord, the Higher Judicial Service rules. Please have a look at page 419. Same compilation, same volume.
200?
490.
419. This is the UP Higher Judicial Service Rules, 1975. As amended from time to time. This comes under Part 4, Procedure for Direct Recruitment. And your lordship will find Rule 18 at the bottom of page 419 is Procedure of Selection. That is direct recruitment.
Direct recruitment for what?
For district judges. And then your lordship will have on the next page, Part 5, Rule 20, Promotion of Members of the Nyayik Seva, as referred to in Rule 5A. And then, my lord, straight away come to Rule 22 at page 421 bottom. Appointment. Subject to the provisions of sub-rule 2, the governor shall, on receipt from the court of the list mentioned in rules 18, 20, and 21, make appointments to the service on occurrence of substantive vacancies. 18 refers to direct recruitment, 20, 21 refer to promotions, all of which comprise appointments. In fact, when a person is promoted to district judge, his promotion order reads as you have been appointed as district judge. नियुक्त किया जाता है.
Try to understand and we'll
Yes.
put it to you how it is.
Lordship, please.
There are two provision and 233, 1 and 2. One confines to only to the judicial officers on promotion, or even take it for appointment. That does not prescribe any other qualification or eligibility criteria, correct? Now, Rule 33, Article 233, 2 speaks about the lawyers other than those who are in employment of state or union. So what, in other words, what you are saying is this. Article 233(1) speaks about the appointment for promotion, which includes promotion of a judge who is already on roll.
No, my lord. Just read 233(1) with me. It doesn't say civil judge there. That's a general, in fact, my lord,
Whatever it may, we take it.
Right,
We'll take it.
right.
See, perhaps we can appreciate your argument if you say 233(2) is the only article which speaks about eligibility criteria.
Correct. That's
So,
what I'm saying.
Therefore,
Right.
that is in common.
Correct, my lord. That's exactly my point.
233,
That's my submission. I'm-
233, Article 233(1), we'll put it this way. Article
Yes, yes.
231 does not speak about lawyers, correct?
It does not speak about civil judges as well. That's a general power.
We will not go into that, that's
Correct.
redundant now, irrelevant now.
Correct.
So we are only concerned with the issue between lawyers and the judges
Civil judges.
with
Yes.
respect to the direct recruitment. That's
Lordship.
why I said promotion, we will not go into the other things.
Right,
There are
right,
two channels, we
right.
will not go into it.
No, so
So nothing much can be said about 233(1). Where 233(2) says, it speaks about for the first time about the lawyers. It speaks about, according to you, it speaks about the right of a lawyer to write the examination to be qualified for the direct recruitment. Only to that
right,
time
correct,
alone.
my lord.
In that qualification is fixed at 7 years. So therefore, your argument, as we understand, is that then in 233(1), which does not prohibit the participation of a common servant, whoever it may be, from being considered for a direct recruitment, this qualification prescribed and under 233(2), ipsa facto will be imported into that. To that extent, we agree.
Yeah,
That's
correct.
what. That's
Now, my lord, the only additional point that
Let us not go into the rules because the rules may be different for
Yes.
every state. Let us confine ourselves to the interpretation of the constitution.
right.
You can't import the provisions of rules to interpret a
In
constitution.
fact, that's something which, my lord, I completely agree with your lordship, my lord. In fact, that is something, the point of whether you can use rules to interpret a provision of an act or even of the constitution. I have been looking for law, my lord, on this aspect that the act or the constitution can be interpreted only directly. You can't use what rule has been framed to interpret that. Otherwise, the position would be
Otherwise,
that you can change a rule and therefore change the meaning of the act or the constitution.
So let
So
us,
I have,
let us restrict also to the interpretation of the.
yeah, correct. So therefore, my lord, leave aside the rules for a moment. I am only saying this, that as Dr. Ambedkar said, this article prescribes the
According to
qualification.
you, Article 233 prescribes for appointment, posting and promotion of the district judges.
Yes, my lord.
And
And
if
therefore the qualification.
And if the contention is to be accepted,
Yes.
then there can't be a promotion by of a civil judge to the district judge.
No, my lord, I'm not saying that. I'm not saying that a person can't be promoted. Yes, he can be promoted. I am saying something a little different. If this is prescribing the qualification, then where is the only qualification that Article 233, my lord, provides is 7 years an advocate? Or that you are, if I'm correct, then 233(2) also prescribes that or you are in the service, which has been not interpreted to mean the judicial service. So therefore, if you say that I am wrong in saying that 233(2) provides for judicial service and doesn't exclude it, and that if they are right in saying it excludes it, then where is the qualification for civil judges in this article? I am saying that there is no qualification therefore prescribed for civil judges because they can't be 7 years an advocate. I'm using that as an aid to say that therefore 233(2) refers to two streams. One, that either you are in the service of the Union of the States, which means judicial service, or you are an advocate. If you take the construction that they are, my lord, espousing, namely that no, 233(2) excludes those who are in service and includes only those who are 7 years an advocate, then in which case, my lord, civil judges will not be eligible to become district judges, even by promotion, is my submission.
That's what we also put it to you, but in different. We are now only one hour left. So
Yes, I'll finish in 1 hour. I'll finish in 1 hour. Now, my lord, straight away, your lordship will come to those two judgments. Just before that, my lord, Shetty Commission will come to later. Just come to those two judgments. First have Rameshwar Dayal, volume 5(1), page 98. If your lordship, my lord, turns to page 100, that's where the judgment starts. A writ was filed, my lord. This just gives the background facts, and I won't read it, my lord. I'll just tell your lordship what they are saying. A writ was filed challenging the appointment of 5 persons as district judges. That writ was dismissed by the High Court, and the ground taken was, and that's towards the bottom of the page at page 100, that they were not qualified to be appointed as district judges under Article 233 of the Constitution at the time when they were appointed by the state government. And therefore, the appointment as such was constitutionally invalid. Now, the facts, my lord, have been, this, my lord, incidentally, as your lordship might note, my lord, that included the appointment of Justice H.R. Khanna, which your lordship will find at the bottom of page 100.
page 100.
Page 100 of that compilation, at the bottom, your lordship will find that one of those 5 people whose appointments was challenged was also...
Compilation.
I'm volume 5, 1. I'm so sorry. The judgment starts at page 98 of this compilation.
You have also given SCC online. So I think
I have not given that, my lord. I was reading it from the SCR because both these Constitution Bench judgments were pre-SCC.
okay.
So later they have been. SCC started in 69. So anything before that, my lord, was not originally in the SCC. Now SCC has kind of taken those judgments and put it in.
Yes, volume page 100.
Page 100, my lord, the judgment starts, and the background facts were that 5 people were appointed as district judges. Their appointments were challenged on the ground that they were not eligible under 233. Now, I was just, Lord, pointing out just as a matter of interest that one of the 5 was Justice H.R. Khanna, who was District and Sessions Judge, Delhi, who later, Lord, came here, whose portrait hangs in Court 2. Then your lordship will have, my lord, page 100 the points for consideration at page the 879, if your lordship has, at page 103. Your lordship will have the facts of 2 of these people. Paragraph 5 at the bottom. Respondent 6, P.R. Sawhney, was called to the bar on November 17, 1930. He was enrolled as an advocate of the Lahore High Court.
I think the issue was whether the practice at Lahore would be taken into consideration.
That was not the only issue. One of the issues was that they were working in the government at the time of their appointment, and therefore would they be eligible at all? Your lordship is right. That was one of the issues. namely their practice at Lahore, would it count or not? So that would apply to my lord H.R. Khanna, etc.
Yes.
But-
Referring to which volume?
Volume
What
5,
about-
sub-volume 1. Volume 5, sub-volume 1. The judgments are in volume 5, my lord. Sub-volume 1 is the very first one of those.
From page to page 401.
So it's like a V1.
VA and VR. Volume VA, VR.
Yes,
I'm so sorry.
105.
103 or
Yes,
respondent PR.
yes.
Money.
Was called to the bar on November 17, 1930, was enrolled as an advocate of the Lahore High Court on March 10, 1931. After partition, he shifted to Delhi, worked for some time as legal advisor to the custodian evacuee property. Then he practiced for some time at Delhi. He then accepted service under the Ministry of Rehabilitation as an officer on special duty and administrator, Rajpura Township. On March 30, 1949, he became the chairman, Jalandhar Improvement Trust. On March 6, 1949, he got his license to practice as an advocate suspended. On April 6, 1957, he was appointed as district and sessions judge while he was, my lord, the chairman of the Jalandhar Improvement Trust. So he was in the service of the union or the state or whatever it was, and he was not an advocate. In fact, he had got his license also suspended and he got appointed. So the question was whether he was eligible or not. Now, also, my lord, at page 103, top paragraph 2, Harbans Singh, he was then the deputy custodian of evacuee property when he was appointed district and sessions judge. So these two people were not lawyers, my lord. They had been lawyers earlier, but were not lawyers at the stage when they got appointed as district judges. Now, if your lordship, my lord, turns to the next page, 104.
Right. Same thing is what with respondent to Urban Singh.
That's right. That's right. That's correct, my lord. He was respondent number 3, Harbans Singh, 103 top.
And the question with regard to Justice H.R. Khanna
Yes,
was with regard to whether his practice at Lahore
Right.
could be
correct,
taken into
correct.
consideration.
So that was a separate
completing
question.
the total.
Absolutely right. Absolutely right. So that, my lord, we are not concerned with whether his practice at Lahore. That was, of course, my lord.
Now, after,
Now, my lord,
the
at
only
page,
question is whether the service of Sawhney
yes. And
and
Harbans Singh, Harbans Singh,
as a service, in the government,
yes,
which was not a judicial service,
correct.
could have been taken into consideration or not.
Not taken into consideration. When they were appointed, they were not lawyers. One of them had got his license suspended and they were working there. He was chairman of the Jalandhar Improvement Trust. Question is, are you eligible? And therefore, my lord, the question of the 233(2), either in the service or advocate of 7 years, that question therefore arose. Now, just have a look at, my lord, 104(2), 104 about... Your lordship has page 104.
Yes.
About 6th line from the top. Two of them, Harbans Singh and P.R. Sawhney, did not have their names factually on the roll when they were appointed as district judges. Your lordship has that sentence, my lord?
Which line?
About eighth line or seventh line from the top, two of them, Harbans Singh and PR Sahni.
PR Sahni.
Yes, did not have their names factually on the roll when they were appointed as district judges because they were not working in the government.
Government, yes.
One of them was the chairman of the Improvement Trust. The other person was custodian of evacuee property. Now, my lord, Article 233 is quoted on that page, and immediately after 233(2) has been quoted, now the argument of learned counsel for the appellant has ranged over a wide field, but the point for decision is a narrow one and depends on whether respondents 2 to 6 fulfilled the requirements of clause 2 of Article 233 of the Constitution when they were appointed as district judges by respondent 1. Then your lordship may have, my lord, page 110.
Two and six, they are one part, and
Yeah.
3 and 4, the other part.
Sorry, I'm sorry.
2 and 6, they fall in one category,
Yes,
and 3 and 4, they fall in other category.
right, correct.
3 and 4 with regard to their experience at Lahore,
Yes.
and 2 and 6 as to whether their service can be considered.
I think, Lord, this Harbans Singh was respondent number 3 and 6. The paragraph is,
Urban was number 2.
Lord, if your lordship has page 103, top of the page, respondent 3,
Respondent number
Harbans
3.
Singh.
Respondent number 3,
Yes.
Urban Singh.
Now, if your lordship turns to page 110,
Yes.
articles about, my lord, 10 lines from the bottom. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article
You
230.
are at page 108.
110, my lord. I'm so sorry. Because before that, my lord, the discussion is about that Lahore part. That was, we are not concerned with that. Articles 124 and 217 are differently worded and refer to an additional qualification of citizenship, which is not a requirement of Article 233. And we do not think that Clause 2 of Article 233 can be interpreted in the light of explanations added to Article 124 and 217. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down, and under clause 1, the governor can appoint such a person as a district judge in consultation with the relevant high court. As to a person not already in the service, a qualification is laid down in clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. The clause does not say how that standing must be reckoned, and if an advocate of Punjab High Court, etc., then skip that part, my lord, and then come to the bottom of page 111. We now turn to the other two respondents, Harbans Singh and PR Sahni, whose names were not factually on the roll of advocates at the time they were appointed as district judges. What is their position? We consider that they also fulfilled the requirement of Article 233 of the Constitution. Harbans Singh was in the service of the state at the time of his appointment, and Mr. Vishwanath Shastri, appearing for him, has submitted that clause 2 of Article 233 did not apply. So therefore, if he was in the service, then itself he is eligible. And this was a direct recruitment, not a promotion. So that is one ground that is given by the Constitution bench. The other ground is the next sentence. We consider that even if we proceed on the footing that both these persons were recruited from the bar and their appointment has to be tested by the requirements of clause 2, we must hold that they fulfilled those requirements. They were advocates enrolled in the Lahore High Court, etc., and that their practice of 7 years would be counted. So the two grounds are given. One, that because they were in the service, therefore they fulfilled it. Because, my lord, 233(2) was read in the manner in which I am reading it. Namely, that two kinds of people are eligible. One, that those who are already in the service, and two, advocates of 7 years. So both the reasonings have been given in this judgment to make them qualify, to not set aside their appointments. Number one, since they were in the service, they qualified. And number two, in any case, their prior experience.
No, but then, even though they were not in the judicial services,
Correct, because that, my lord, came only by way of Chandra Mohan.
Chandramohan.
Yeah, that came only later, because till then your lordship saw.
But then what is most important to you
Yes,
is observations in page 110, last 7-8 lines.
yes. Yes, ma'am. Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the union or the state, no special qualifications are laid down. Absolutely right, my lord. Absolutely right.
But how does Dhiraj More distinguish this?
I'll show your lordship, my lord. It just says, no, this is something totally different. I don't know how it's been distinguished. Chandramohan is even clearer. I'll show to your lordship Chandramohan.
Let us go to Chandramohan.
Yes, straight away, my lord. Now, Chandramohan is, my lord,
Because this was 5 judges.
both of them are 5 judges.
This was also 5 judges.
This is also 5 judges. Chandramohan is also 5 judges. Both were binding, my lord, on Dhiraj Mohan.
Binding on Dhiraj More.
Yes, absolutely right. Page 180, my lord, of the very same compilation, your lordship will find Chandramohan. If your lordship turns to page 183, that's where the judgment starts. I'll just read that first paragraph, my lord, because there is a phrase called judicial officers who are actually from the executive department. That has created a bit of a confusion. In Dhiraj More, they say that this part goes against you because they hold that these judicial officers were not qualified. Judicial officers here, they state in this paragraph, was a euphemism used for those in the executive service. I'm reading, my lord, between placetum C and D on page 183. The facts may be briefly stated. During the years 1961 and 1962, the Registrar of the Allahabad High Court called for applications for recruitment to 10 vacancies in the UP Higher Judicial Services from barristers, advocates, vakils, and pleaders of more than 7 years standing, and from judicial officers. The expression judicial officers is a euphemism for the members of the executive department to discharge some revenue and magisterial duties. Selection committee constituted, etc. Then, my lord, between placetum E and F, respondents 2, 3, and 4 were advocates, respondents 5, 6, and 7 were judicial officers. Then, my lord, at placetum G, thereafter the appellant who belongs to the UP Civil Services Judicial Branch, who was at the time acting as district judge, and others who were similarly situated as the appellant, filed petitions in the High Court at Allahabad under 226 for an appropriate writ directing the government not to make the appointments to the UP Higher Judicial Service pursuant to the said selection. So he didn't say that appoint me or that I was eligible or that I should have been permitted to sit in the exam. He only challenged the appointments of those persons. Then your lordship may have, my lord, 2 pages later at page 185. Placetum C, the argument of learned counsel for the appellant may be placed conveniently under the following 5 heads. 1. While under Article 233(1) of the Constitution, the governor has to make appointment of persons to be and the posting and promotions of district judges in consultation with the High Court concerned under the rules made by the governor under Article 309 of the Constitution. He has to consult before making such appointments a selection committee constituted thereunder, and therefore the appointments made in consultation with 2 authorities instead of 1 as provided by the Constitution were illegal. 2, on a fair reading of the provision of the rules, it is manifest that the High Court is a transmitting authority, etc. Just leave that, my lord, for the sake of time. Just come to 3.
The governor has no
Yes,
power.
the governor has no power to appoint district judges from judicial officers as they are not members of the judicial service. The exclusion of the members of the judicial service in the matter of direct recruitment offends Articles 14 and 16 of the Constitution. Alternatively, the exclusion of members of the judicial service in the matter of direct recruitment to the post of district judges while permitting judicial officers to be so recruited offends the said article. Then, my lord, your lordship will have page 189. Placetum F. The third point. The third point raised is one of far-reaching importance. Can the governor, after the Constitution, directly appoint persons from a service other than a judicial service as district judges in consultation with the High Court? Can he appoint judicial officers as district judges? The expression judicial officers is a misleading one. it is common case that they belong to the executive branch of the government, though they perform certain revenue and magisterial functions. The relevant article on which both parties rely is Article 233, then that is quoted. Then your lordship will have the next page. While the learned counsel for the appellant contends that the said article must be read along with the group of articles embodied in Chapter 6 of Part 6 of the Constitution and also in the background of the history of the said provisions, and that if so read, it would be clear that the governor can only appoint district judges either from the judicial service or from the bar. The learned counsel for the respondents, on the other hand, argues that Article 233 is expressed in general terms and there is no warrant to restrict the scope of the said article by construction or otherwise. Then your lordship will have, my lord, 2 pages later, page 192, after, my lord, the various other articles in that same part are quoted.
No, you can read to the third paragraph also, that is also important.
Which one? I'm sorry, my lord.
Page 190,
190. Yes.
before construing the said provision.
Before construing the said provisions, it should be remembered that the fundamental rule of interpretation is the same whether one construes the provisions of the Constitution or an Act of Parliament, namely that the court will have to find out the expressed intention from the words of the Constitution or the Act, as the case may be. But if, however, two constructions are possible, then the court must adopt that which will ensure smooth and harmonious working of the Constitution and eschew the other which will lead to absurdity or give rise to practical inconvenience or make well-established provisions of existing law nugatory. Grateful. Then, my lord, may I take your lordship to 192? After that whole chapter in the Constitution is quoted. Third line, top of the page.
Page?
Page 192, third line from the top. The gist of the said provisions may be stated thus. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state. There are two sources of recruitment, namely one, service of the union or the state, and two, members of the bar. Please mark this, my lord. Two sources of recruitment. The said judges from the first source are appointed in consultation with the High Court, and those from the second source are appointed on the recommendation of the High Court. The article doesn't say that the first source will be only by way of promotion. That will be in consultation, because under
That may be their argument.
and that it is only by way of promotion. That is only their argument, and somehow it is not there anywhere in the article, but somehow it has come from somewhere. But in the case of appointments of persons to the judicial service other than as district judges, they will be made by the governor of the state in accordance with the rules framed by him in consultation with the High Court and the Public Service Commission. But the High Court has control over all district courts and courts subordinate thereto, subject to certain prescribed limitations. So far, there is no dispute. But the real conflict rests on the question whether the governor can appoint as district judges persons from services other than the judicial service. That is to say, can he appoint a person who is in the police, excise, revenue, or such other service as a district judge? The acceptance of this position would take us back to the pre-independence days, and that too in the conditions prevailing in the princely states. In the princely states, one used to come across appointments to the judicial service from police and other departments. This would also cut across the well-knit scheme of the Constitution and the principle underlying it, namely the judiciary shall be an independent service. Doubtless, if Article 233(1) stood alone, it may be argued that the governor may appoint any person as a district judge, whether legally qualified or not, if he belongs to any service under the state. But Article 233(1) is nothing more than a declaration of the general power of the governor in the matter of appointment of district judges. It does not lay down the qualifications of the candidates to be appointed or denote the sources from which the recruitment has to be made. But the sources of recruitment are indicated in clause 2 thereof. Under clause 2 of Article 233, two sources are given, namely one, persons in the service of the union of the state, and two, advocate or pleader. Now, this is not just pausing here for a moment. They are interpreting 233(2), that under 233(2), two sources are given. One is persons in the service and the other is advocate or pleader. And yet, my lord, Dheeraj Moore says ki no, 233(2) excludes those in service. Completely contrary to this. It does not lay down the qualification. But sources of recruitment are indicated, namely 1 persons in the service and 2 advocate or plead. Can it be said that in the context of Chapter 6 of Part 6 of the Constitution, the service of the Union of the state means any service of the Union or of the state, or does it mean the judicial service of the Union or the state? The setting, that is the chapter dealing with subordinate courts in which the expression the service appears, indicates that the service mentioned therein is the service pertaining to courts. That apart, Article 236B defines the expression judicial service to mean a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. If this definition, instead of appearing in Article 236, is placed as a clause before Article 233(2), there cannot be any dispute that the service in Article 233(2) can only mean the judicial service. Namely, judicial service is included in Article 233(2). The circumstances that the definition of judicial service finds a place in the subsequent article does not necessarily lead to a contrary conclusion. The fact that in Article 233(2) the expression the service is used, whereas in Article 234 and 235 the expression judicial service is found, is not decisive of the question whether the expression the service in Article 233(2) must be something other than the judicial service. For the entire chapter is dealing with judicial service. The definition is exhaustive, etc. Then your lordship will have just above placetum D, having defined judicial service in exclusive terms, having provided for appointments to that service, and having entrusted the control of the said service to the care of the High Court, the makers of the Constitution have not conferred a blanket power on the governor to appoint any person from any service as a district judge. Reliance is placed upon the decision of this court in Rameshwar Dayal in support of the contention that the service in Article 233(2) means any service under the state. The question in that case was whether a person whose name was in the roll of advocates of East Punjab High Court could be appointed as a district judge. In the course of the judgment, Justice S.K. Das, speaking for the court, observed, Article 233 is a self-contained provision regarding the appointment of district judges. As to a person who is already in the service of the Union of the state, no special qualifications are laid down. And under Clause 1, the governor can appoint such a person as a district judge in consultation with the relevant High Court. As to a person not already in service, a qualification is laid down in Clause 2, and all that is required is that he should be an advocate or pleader of 7 years standing. This passage is nothing more than a summary of the relevant provisions. The question whether the service in Article 233(2),
as a matter of fact, they depart from the view taken in Rameshwar there. Though
to the extent, yeah, your lordship is right, because that's
says that any service.
right. Because, my lord, they had cleared people who were not in the judicial service, namely those two.
That was the situation then.
Correct.
Now.
That is correct. Your lordship is absolutely right. As a matter of fact, they depart slightly to limit it to.
It is under the constitutional scheme.
They raise their foundation on the doctrine of
Yes.
separation of powers
Yes.
and independence of judiciary.
Correct.
Yes.
Correct. But one thing is clear from both the judgments, that 233(2) includes both these streams. Both the judgments say it. And as your lordship rightly asked, my lord, how did Dheeraj Moore come to the conclusion that no, it's an exclusion rather than an inclusion? Then, my lord,
Stream is something which is created by us, not under the constitution. The constitution merely says promotion and then direct recruitment, that's all. Qualification is the time, and obviously lawyers cannot be considered for promotion because they are not working as judicial officers. There is no exclusion of judicial officer under 233(2).
yes.
I mean, if it is recruitment is there, expressly.
Then, my lord,
Last line question about the proposal.
that fourth question, can people in the judicial service be excluded? Your lordship had seen questions 3 and 4 were relevant. So 3 they answer by saying that no, this has to be only the judicial service, not the executive service, not any other service. And 4 they leave open. They don't answer that at all. Can they be excluded? That your lordship will find, my lord, at page 195. The small 2-line paragraph between placetum C and D. In this view, it's not necessary to express our view on the last 2 questions. But naturally, the corollary of what they've held would be that you cannot exclude the judicial service. If there are 2 streams, one is the service, which means judicial service, and the other is advocates, In fact, I'll come to that in a moment, my lord. And that is the next issue that I need to address before your lordship. So therefore, my lord, on the first point, hmm? Can't see. वो जो हो रहा है करें Now, Lord, so therefore, in my humble submission, I have finished with the point of whether 233(2) includes that second stream.
According to the 233, who includes both the streams.
Yes,
And the finding of Dheeraj More,
is
that
completely wrong.
233(2) is exclusively
Yes.
for the members of the bar,
Now, Lord,
is not correct.
correct.
In
Now,
other words, we'll try to actually understand the argument.
yes,
233, 1 and 2, they speak about, they don't distinguish between the promotion and other things. So therefore, qualification is in 233.
Lordship.
And then 233, one it generally speaks about who is the authority to do it, whether it is promotion or a recruitment or appointment.
Correct, correct.
These are all general.
Right.
Governor in consultation with this. And then second thing, it only specifies the qualification of the lawyer. Therefore, you have to read 1 and 2 together.
Absolutely.
One does not restrict only to the judicial
very-
officer, and therefore 2 does not restrict to the lawyers.
Correct.
They both will have to be written in consonant.
Right, right. That's exactly, Lord, how the two constitution benches.
Lawyers cannot get into obviously promotion.
Correct,
There's no bar for them to come under that.
Right.
Because there is no express exclusion.
right, right. Now, Lord, that leads me to the next question, which is, supposing the Constitution provides for these two sources, can by rules, can you exclude one source completely from direct recruitments? And that immediately raises, my lord, the Article 14 question. Now, in this context, please note, my lord, that all the judgments which have dismissed the Article 14 argument base it on their Lord finding of 233(2) itself excludes those in judicial service in direct recruitment, and therefore you're not eligible. Therefore, there's no question of Article 14. None of them has gone to the extent of saying, no, there are two sources, but one can be completely excluded. So the Article 14 question is very, very Lord clear. If there are two sources provided for by the Constitution, according to me, my lord, one, you cannot just shut out one. Then you are doing something contrary to what Volume 5 to PDF 72. It's showing Shetty connection first. It's volume. So therefore, my lord, my submission on this is, if the
Which are, whether the rules framed by the state governments in consultation with the High Court provide for exclusive bar members.
yes, it does, my lord. Your lordship will have a look at volume 4. We have the UP